the end of the year, there will be 30 states that are ready to be part of the compact. There's no date for the official rollout. I mean, it will be determined by the database, solving some of those bigger problems. But hopefully by the end of the year, or certainly by the beginning of next year, the compact will be ready to go. And that's what I have about the compact. Does anybody have any questions about any of that?
Can you all hear me? This is Andrew.
Hi, Andrew.
Hi. So I had a question. I had a comment about this. So one of the things I am actually on vacation driving in Mississippi somewhere, but I wanted to join in for the time that I could. So my apologies for being late.
No, I'm glad you're here. Oh, I think we lost him.
Andrew, can you still hear us okay? Well, we might have to come back to him when he gets. Yeah, he did drop off. So I'll keep an eye out for him and see if he logs back in.
Okay, well, we'll jump back to him if he can dial back in. So any other questions about the compact before we go to information on the conference? Okay. I'll start about the conference. I just want to say, I know David's going to give a review of what we covered at the conference, but David Fye did a presentation on applying public protections, and he did a great job. He is well respected with our peers. That people like to have David speak. He gets a lot of really favorable, feedback about what he does. He's known as being conscientious, thorough, and kind. And it really shows through in his presentation. So he did a great job. And I just wanted to say that, David, because our advisory committee doesn't get to see you in action.
Thank you, Laura. I appreciate that.
So go ahead and tell us about the conference.
Okay. Well, so the conference picked up right as the Compact Commission meeting was ending. It was kind of a springboard. So Laura attended that on behalf of Kansas, and then we started with the NBCC conference. And Laura, I appreciate the compliments. Yeah, I was asked to present information. I've been fortunate enough to be asked to talk at their conferences for the last 3 years now. The first year was as part of a mock disciplinary hearing, and I played one of the attorneys through that process. And that was a really interesting exercise to kind of hear thoughts and feedback from different people. And then last year I talked on creative licensing. And then this year I was asked to talk about public protection, specifically in the area of educational reviews, especially educational reviews that involve substantial equivalence. When someone applies for licensure and they come from a school that is not accredited by the national accrediting body. So for counseling, that would be CACREP. And so I kind of outlined some of the values that the board has in this area, and then some of the priorities for the staff, and then people outside the agency, the applicants, members of the legislature, and then talked about what our process was in terms of how we have moved through different options to try to provide a situation to where board members are not wearing too many hats, and we have a good, clean process with that, and also that we're not overly taxing staff and allowing experts to do something that involves some expertise. And so it was really, really good. We also had an exercise. I had individuals who were present put themselves in the position of an agency that did substantially equivalent license reviews. And I had some of the people as if they were board members who had to perform that function themselves. And what were the pros and cons if that is that is something that they did, or if they were part of an agency where the staff did that. And then I had another group where they contracted with experts. And so it was nice to hear the different thought processes from people, especially if they have not gone through the same steps that we have. But it was well received, and I was really happy to hear about that. So Andrew is back on the call. Andrew, this is we're talking about the next item in the agenda, but we can come back to the Compact conference here in a little bit. I just was giving some notes about the NBCC conference, and just a couple other notes that I had in terms of what I heard and what I picked up from the conference. As Laura mentioned, SIPAC is a compact for licensed psychologists. They have some similarities to the professional counseling multi-state compact in that it's not one where psychologists are automatically a member of the compact. They actually have to choose to pursue compact privileges. And if they do pursue that, then they can have the ability to practice under that compact. And as Laura mentioned, about 15% of licensed psychologists are practicing under SIPAC authority from the states that have joined SIPAC. And so there was also some information that was provided in terms of some states that have experienced challenges. It's always nice to put things in perspective. I know in my role, I get a chance to talk to members from other states and jurisdictions and hear about their licensing processes and some of the challenges they face. There were some representatives from Tennessee who spoke about that. They said over the last 5 years, they've had about 100% turnover in leadership, including changing their board's attorney. They said that at one point they had fallen so far behind with license processing that the average processing time was 9 months for all licenses, and that they had a backlog of about 600 applications. So they have really worked to resolve that. And the success they reported now is that their time frame on average is down to about a 6-month processing time frame, which is significantly improved. We try to tell individuals that under most circumstances to allow between 30 to 45 days after we have a complete application, but in many cases we're able to process things much more quickly. But it's helpful to hear about some of the other states when they have experienced difficulties. They also had difficulty with things like responding to questions. As you might imagine, when there are 9-month processing timeframes, you get a lot more questions from the public in terms of people wondering about the status of their applications and things like that. But now that they're in better footing, they're looking at some different topics that the board here in Kansas is looking at as well, which I found kind of interesting. They are working with the e-broker, which is a group that had presented information to the board here in Kansas. That is a group that allows individuals to post their records from attending continuing education classes, so that if they're audited, the board can look to the website and see all the materials versus having them send it in. There's also some ways that people can pursue more information about continuing education opportunities that way too. They are also looking at an RFP for an impaired provider program, which is something that our board had just recently discussed. And then they are also in the process of developing a jurisprudence exam. And I heard several different states mention a jurisprudence exam, not as a way in which you would prevent people from becoming licensed, but as a way that it could be used as a learning tool, so that if individuals are renewing their license, you make sure that they actually do understand the rules that they are agreeing to follow. And so I found that pretty interesting. They are also looking at standardizing rules across their different professions. They have a composite setup as well. And they were discussing the topic of supervision and whether it's appropriate for other professions to provide supervision to counselors, which is a topic that we have on the agenda as well today, in a way. And so I found that pretty interesting. There was also a representative from a licensing board in Arizona, and she talked about ethics. She said that in their state, about 80% of the violations deal with boundary issues. And that's not always a sexual relationship with clients, but could be inappropriate friendships, some where the attorney or the counselor is a landlord, perhaps, or just different types of dual relationships. It also could involve inappropriate contact and communication through social media. So that was also something that I found interesting. In Arizona, they have 20 staff members, so it's always nice to keep things in perspective. We have 10 currently. We're moving to 12, which is a big increase for us, but it's interesting to hear about those that are much bigger. They also have a jurisprudence exam they started in 2018. It is a way that they can walk through, and so when individuals take it, they don't fail, but if you miss a question, you go through a part to where you have to review information to make sure that you're knowledgeable about it. So it's more of a learning tool. They have mentioned that one of their victories has been moving from paper mailings to all licensee emails, which is one of the things that we use here. They also reach out to universities and provide presentations, which is something that Leslie and I have done quite a bit of and are looking to do more of. And then they mentioned for their board meetings, they don't broadcast the meetings, they are only in person. However, they have about 40 to 50 people from the public who attend their meeting, which I thought was really interesting. That would be very difficult for us to do based on the fact that we rarely have public attendees at most of our meetings, but just interesting to hear different perspectives. And so some of the other states, as we were talking about different presentations, they were talking about wanting to improve things like the quality of supervision. There wasn't a definite answer to that question, but it was one that people were pondering. And then there was also a presentation on universal licensure. And universal licensure does differ state to state, but the basic premise is that there was a movement a few years back, maybe 2, 3. Some of the states are currently just seeing that now, but it primarily involves military members and military spouses as a way for more people to be able to get licensed more quickly if they've been practicing in another jurisdiction. In Kansas, it wasn't a complete model of universal licensure that matches what other states had allowed, but it did shorten the time frame for a lot of people that either are military members, military spouses, or those that reside in Kansas or intend to reside in Kansas. And some of the items the board put into the bill that passed this year shortened the time frame for reciprocity for certain applicants, in part to kind of match the time frame of some of those types of changes. And then there was one other presentation I thought was kind of interesting. It was one of those that was sort of looking to the future, and it discussed a little bit of use of psychedelics in terms of therapy. I'm not sure completely what to take away from that, except to say that I know that people are having those conversations and the appropriateness or inappropriateness of using psychedelics in terms of therapy. So it was interesting to hear some of that conversation, but it definitely wasn't an endpoint in terms of what's appropriate or what's not. It was just interesting to hear what is being communicated in other jurisdictions. So there were other good presentations, but I think for the purpose of time, I'll go ahead and kind of pause and see if any of you had any questions about that conference.
Thank you, David. Any questions? Okay. Thank you for the report. Yeah, it was very interesting. And yeah, the psychedelic one, they ended with that one. That was the last presentation, oh, one of the last presentations. And it was definitely a unique one. They are trialing oral ketamine that can be used in a counselor's office, prescribed, of course, by a physician or a psychiatrist. But that the thought is that those experiences will be happening in the offices of counselors. So it opened up a lot of questions, needless to say. Again, thank you, David, for that report. And if anybody has any questions, you can contact one of us. We were both there, so please do. The next thing that we have, training for board members and for committee members. So David, you want to take that one?
Sure. So there are a few different items for this training, but what I've done instead of jumping back and forth is I put together sort of a PowerPoint, and I'll go ahead and share my screen here for the PowerPoint, and we'll go ahead. This was not sent out. This is kind of a lengthy PowerPoint, but I think it's a real good training. I know you may have seen this already, but we will go ahead and post this on the website afterwards if you have questions, but it walks through some of the other documents that we have.
David?
Yeah.
Before we do that, should we go back to Andrew and see if Andrew wants to talk about the compact? I don't want to put him off too much, especially because he's driving.
Yes, that's a good idea. Andrew is back on the call. So.
Andrew, are you there?
Yeah, sorry. Yeah, I'm here. Can you all hear me okay?
Yes.
Okay. Can you tell me what it was that I last said? I don't want to take more time than needed.
We didn't get anything from you. You just start at the very beginning.
Okay. Well, I'll just make it quick. So there's a couple things about our compact that differ from maybe SciPac that may affect. It could be the 15%. I don't know how it would take off, but with how rapidly it was approved by so many states. I know SciPac was around. It's been around since sometime in the earlier 2000s, maybe 2010, somewhere around there. Maybe, I don't know. I looked at it, but it's been around for a little bit longer than ours, and I was surprised by the number of states that hadn't already approved it and how long it's taken to get to the numbers that we're seeing for counseling after only our third legislative session. So I thought it was interesting how quickly the counseling compact had moved forward,
Yeah.
which may be because it already states with that compact, with SIPAC. The other thing with ours is that I was told by the folks at the Council of State Government that our compact bill covers both in-person and telehealth practice, where SIPAC only covers telehealth practice.
Mhm.
So with a couple of those things, I just want to throw that out there as people learn more about it, the way that could both have the speed with which our compact has taken off, and then the way in which it operates. I don't know how that may affect the number of professionals that pursue it, as well as potentially the thing that I think is also another unknown is the number of professionals that do not pursue their clinical license, that as a result of the compact may then pursue this clinical license. That could increase the numbers of professionals that we have that are on the clinical side, since I imagine many of us know people that have just never chose to pursue it because they didn't really see, quote unquote, the benefit of taking that extra step. So just a few factors I thought could be interesting as we consider what our response to it looks like.
Yeah, that's great feedback. Those are both, it sounds like both of those would point in the direction of more people pursuing the compact, more people pursuing their LCPC is what you're saying.
Possibly, yeah. I mean, it's just something to watch. I know that when David and I were at NSLOR, when we were at the governor's office for the meeting, she was asking about tracking. And so I know that she will be curious in some way to know, I think, in terms of what our numbers look like, in terms of people taking this on. I also think the other part would be looking at some of the surveys where Kansas's numbers were rather low, and seeing how Kansas is reflected in those rankings in the coming years after the compact takes off, as a way to also potentially demonstrate the way the compact may be affecting in some way what mental health care looks like in our state.
Which is, of course, the goal, to increase all those numbers. David, do we have the tracking in place for that? Do we have data that we can start and gather?
For the professional counseling compact? I think that will probably be something that will be reported to us from the Compact Commission.
Okay.
If it follows the SIPAC model. I was just looking at one just slight correction. It is true that the vast majority of people who practice under SIPAC are only doing the telehealth or the teletherapy. When SIPAC was started, there were two different options you could pursue. You could do something called an APIT, or you could do something called a TAP. The APIT has to do with telehealth, and it is much more prevalent. For example, in Kansas, the APIT, we have 85 licensed psychologists who are practicing the telehealth using that APIT from SIPAC. Alternatively, SIPAC allows you to apply for up to 30 days of in-state physical practice, but it's separate from the telehealth, and it's much less popular. So for Kansas, we only have 8 licensed psychologists out of about 1,000 licensees who have pursued that in-state option. And so it is, I don't want to mislead anybody. There is an option to do in-state practice, but it is not a full authority like you would have with a license. But the telehealth option is much more popular than the in-state practice option.
Great. Thank you for that. Andrew, thank you for your feedback.
You're welcome. Thank you.
Okay, shall we go on with training? I'm sorry to interrupt you, but I know he's driving.
Yeah, no, that's a very good idea. And like I said, you did not receive this PowerPoint, but I will go ahead and post it on the website. It probably is too big for me to actually send out by email in terms of the PowerPoint, but I did send 3 documents that are all posted on the BSRB website, and they are posted with the materials for today. One is an expectations of board members document. The other is an advisory committee policy. And the third is guidelines for public attendees of meetings. And the reason why I provided those to you, when we do our annual training, we try to combine the training for board members and also that for advisory committee. And then we developed a document for public attendees as well. So the idea that in understanding your role as an advisory committee member, some of that is understanding what the role of the board is first, and then understanding how your role as it fits within the context of the board. So let me go ahead and share my screen here with the training. And then I probably will not be able to see if you raise a hand during the training. So please feel free to let me know if you have any questions just by indicating that you have a question. But go ahead and share that again. Okay. And then are you seeing the version that's the full screen, or are you seeing the version that has the different slides to the left?
We have the different slides to the left.
Okay. Okay. Well, let's go ahead and try this for now.
It's big enough to read.
Yeah, I'll go ahead and do that, and then we'll kind of go from there. Okay. Okay. So this is the annual training for board members and also for advisory committee members. And just to kind of outline the basic mission of the board. So mission of the BSRB, in accordance with the intent of the Kansas legislature, is to protect and serve the consumers of services offered by BSRB licensees. And that's through the issuance of licenses, resolution of complaints, and the creation of appropriate regulations accomplished through efficiency, fairness, and respect to all those involved. A little bit of the history of the BSRB. BSRB was formed in 1980. The Kansas legislature did create the BSRB by combining the Board of Psychology Examiners and the Social Work Examiners of the board. A little bit of the history over the years, the BSRB's jurisdiction was expanded to include the licensure of professional counselors, master's level psychologists, marriage and family therapists, addiction counselors, and also behavior analysts. The board is something called a composite board, rather than have a separate board for psychologists, social workers, professional counselors, marriage and family therapists, addiction counselors, and behavior analysts. There is one board, and it's composed of professional members and public members. And so the combination of individuals on one board is what we call a composite board. In terms of some of the benefits of a composite board, we utilize a composite model, and in doing so, the agency saves a significant amount of operational expenses by sharing resources and utilizing licensing and investigation staff for similar areas. And one way to help understand your role as an advisory committee member is to understand the difference between a board versus an association. A regulatory board, it exists to protect consumers, and it's created by the legislature, and it's governed by statute, and statute is another word for law, whereas an association exists to enhance the profession and is often created by the profession. In terms of our staff, we currently have 10 staff members, including myself, Leslie, the assistant director and licensing manager, licensing specialists, investigators, and clerical employees, and we are soon to move to 12 members of our staff. In terms of agency operations, we are a fee-funded agency, and we do not receive any money directly from the state general fund, but by statute, we contribute up to 10% of our revenue every year to the state general fund, which maxes out at $100,000 per year. All of our revenue, or the vast majority of it, is from license fees, and our annual budget is a little over $1.1 million. As a small agency, the BSRB contracts with and has agreements with many different agencies. In terms of the board, all board members are appointed by the governor to serve 4-year terms. and may be reappointed for a second term, allowing service on the board for a maximum of 8 consecutive years. In terms of the actual board composition, there are 2 psychologists, licensed psychologists with PhDs, 2 social workers, 1 marriage and family therapist, 1 professional counselor, and 1 addiction counselor, and 1 master's level psychologist. There are also 4 public members on the board. In terms of the functioning of the BSRB, there's 2 basic functions of the agency. One is licensing, and the other is investigation of complaints or discipline. And then in terms of the licensees regulated by the BSRB, there are currently about 15,155 active permanent licenses under the BSRB. These are on the 7 different categories of licensure that I already mentioned for the profession. And just to give you an idea of the rough totals here, this was a snapshot that was taken for the last board meeting at the beginning of July. This shows that our biggest profession by licensee totals is social work profession, and in terms of the specific license type, the largest number is those master's level social workers. The next largest is the clinical level of social workers, those licensed specialist clinical social workers. However, there are also quite a few individuals in the professional counseling and clinical professional counseling category, and other professions listed here as well. In terms of new licenses, in FY 2023, which is the fiscal year that we just ended, the BSRB issued over 1,500 permanent licenses. We also issued 433 temporary licenses, and then 66 out-of-state temporary permits. I just mentioned with the psychology multi-state compact that for that compact, there is an option to do a certain number of days, up to 30 days of in-state services in other compact states. And Kansas, one of our options for out-of-state practitioners is they can essentially do something similar here. They can get an out-of-state temporary permit, which is good for 1 calendar or one year, and you can practice up to 30 days under that out-of-state temporary permit if you are at the appropriate license level, which is generally the clinical level. In terms of original licenses and reciprocity, so out of the 1,586 permanent licenses issued by the board, about 1,100 were initial licenses, and then 462 were by reciprocity. So about 1/3 of our licensee totals are reciprocity, people coming from other states. In terms of renewals and audits, I mentioned we were pulling some of the information, some we have, some we're still working on. So these are the totals from last year, but I think we should see similar numbers this year. Last fiscal year, we processed about 6,214 license renewals. And then just to let you know, as part of our renewal process, 10% of all applicants are audited to ensure they have met the continuing education requirements. And in FY 2022, the BSRB audited 625 individuals. In terms of licensing trends, since July of 2015, the number of permanent licensees has increased by 24.7%, from 12,152 to 15,155. And the professions with the largest increases are professional counseling, social work, and behavior analysis. And one reason I wanted to highlight this is that sometimes, there can be some misinformation that is shared. Over that time period, I believe the population of Kansas in total has risen by a little over 1%, definitely less than 2%. But in terms of our licensees and people getting licensed and joining the profession, we've seen a significant increase. And that's part of the reason why we need 2 more staff members to help us out. We do have the new responsibilities, but also we have professions that are growing, and they're growing significantly. And so there's always ways that we can look to make sure that we have good policies and making sure that we are licensing people appropriately. But if you have any questions about are more individuals getting licensed than previously, are our licensing totals growing, they are definitely overall growing. Now that's not true for every profession, that it's all growing at the same rate, but overall we are seeing increases in our licensing totals. I mentioned that the BSRB has 2 primary roles. One is to oversee licensing, and the other is investigation and discipline. And so in terms of the second responsibility of the agency, as a public protection agency, the BSRB investigates complaints against practitioners under the authority of the board. The agency has administrative authority over practitioners, but this process does not take the place of criminal proceedings or civil proceedings. So sometimes when we get an investigation against an individual, we always try to be mindful that someone may be confused from the outside and may think that they need to come to us instead of going to the police if it's a criminal matter. And that's not our role. And so we always stress that we have authority, and it's administrative authority over the licensee and their license to practice under the professions that we regulate. But we do not serve the same function in terms of a criminal process. And also, if someone is seeking to sue someone in a civil court, that's not the role that we play either. So we always try to clarify our role in that process. In terms of complaints, last year the BSRB received 200 complaints or report of alleged violations against practitioners. For comparison, last year we received 205, and then the following year in 2021 we received 132, and then 199 in 2020 and 201 in 2019. And if you're looking at those numbers and the 2021 numbers seem very strange, that is true. We don't know completely why that occurred, except that that was a trend across different states. This was during some of the initial stages of the pandemic, and we just know that there were fewer complaints being reported during that time period. But prior to the pandemic, we had seen our totals rise up to about 200, and since things have started to come back to normal after that, we've seen our total numbers come back up to 200 and kind of stabilize. But the complexity of the cases has continued to rise. So we are seeing cases that involve more different types of complaints or needing more investigations against those individuals. When it comes down to our investigative process, complaints are reviewed to determine whether the BSRB has jurisdiction over the issue, and also whether the matter involves a potential violation of the statutes and regulations of the profession. Complaints and RAVs are reviewed by a subset of the board. It's also known as the Complaint Review Committee. In terms of common violations, examples of common violations include falsifying continuing education requirements, such as an audit violation, practicing without a license or expired license, also having dual relationships or conflicts of interest, making sexual advances towards or engaging in physical intimacy with any client, refusing to report termination or suspension, confidentiality violations, or practice issues, such as performing services inconsistent with one's education or accepted professional standards. And that's not the complete list, but those are some that we see fairly common. Another role that the BSRB holds, I mentioned licensing, investigation of complaints, and the disciplinary measures, but also we do outreach. The assistant director and I, we talk with different groups of students, primarily to provide information on licensing and also disciplinary matters. And we provide a proactive approach to assist individuals before they become licensed. We're still pulling the numbers on how many presentations we gave last fiscal year, but the year before in 2022, we gave 18 presentations. Additionally, we launched a YouTube channel back near the first year of the pandemic. In January of 2021, just about a month and a half after I came over and started working for the agency, we launched the YouTube channel, and this was done to make sure that our meetings were more secure and also make sure that there was more public access to be able to attend our meetings. And in terms of that process, since January of 2021, we have broadcast about 124 board and advisory committee meetings, and those have been streamed live or uploaded. They have been viewed over 4,300 times. So I think prior to us using a YouTube channel, from what I understand, the board maybe had 10 individuals in a given year who came to meetings and provided public comment between board and advisory committee members. And if you look at that total in just 2.5 years, we've had 4,300 individuals who've been able to, that probably involves a few of the same people, but still, thousands of people potentially that have had the opportunity to view our meetings, not just when they are live and aired, but to go back afterwards. And if there's certain topics like compacts or legislation, or any different topics that would be of public interest, I think it's a huge success that we've been able to bring these to the public in more detail. Additionally, one of our resources I want to make sure that you all are familiar with is the website for the agency at bsrb.ks.gov. On that website, we post a lot of helpful resources. Some of the features on the website, there's a portal to renew licenses. There are copies of forms and other applicant materials, copies of statutes and regulations, proposed changes to statutes and regulations, complaints and review of alleged violation forms, disciplinary orders, information on board and advisory committee meetings. And so we really do try to make sure that if any individuals from the public want to follow along, or if individuals want to go back and research any topics, we try to make sure that information is available for people to follow along. And then also as our duty is to provide public protection, we want to make sure that information is out there for the public as well. Now let me go and I'm going to stop sharing my screen just for a second. And I'm going to make one little adjustment here, and then
Bob, have you heard all of this a few times?
Just a few.
yeah, I appreciate those of you who have attended the training in the past. I know this is information that is familiar, but I think it's a good reminder just to make sure that we're all mindful of these different things.
Definitely.
I apologize. We're having a little bit of technical issues this morning with the PowerPoint, but I'm going to try to close it and reopen it here. Okay. I guess I can, while this is doing the technical step, does anybody have any questions so far over the material that we've gone through? I know some of this is presented to the board with some frequency. We try to give sort of a recap of some of this information the start of the fiscal year in terms of license totals and other numbers, but.
David, can I ask a question about the review process for complaints?
Yes, that'd be good.
So when a complaint is sent to the BSRB, the way that if I can understand this, so the complaint initially goes to an investigator. An investigator reviews it. A letter is normally, then if there's alleged misconduct, is sent to the licensee that's in question to provide a response. And then that information is reviewed. I don't know, that come back to the investigator, and then what happens from there?
Yeah, so, and there are a couple steps at the very beginning too. So if we do receive a complaint, an individual, there is first sort of an evaluation to make sure that we have jurisdiction over the person. Sometimes there can be a little confusion between a psychologist or a psychiatrist. Psychiatrists have a medical degree, so they're overseen by the Board of Healing Arts, or at times there are people from out of state, let's say a counselor from Missouri, and we get some of those from time to time, and so we have to refer them to the appropriate place. But if it is someone that we have jurisdiction over, then we look to see, okay, if all things were true, would this still be a violation of the statutes and regulations? And if it would be, then we proceed with the investigation, and we do send a message to the licensee to inform them of the complaint, and then we ask for a response. And so we ask them to provide any additional information to us that would be helpful for the board to consider. And then based on what they provide back to us, sometimes we would follow up again with more direct questions on certain things. And that would give them the opportunity to provide information to us, or for the individual who submitted the complaint, if it deals with some records, we might need for them to sign a release just to make sure that we have the authority to review those records. And so that's kind of part of it too. But once it gets to the spot to where the individual who's licensed will get the opportunity to provide a response, then yeah, they would be presented with that, and they would have the opportunity to send back information to us.
And then at that point, once all the information is gathered, I know there's a few different ways this can go. It can either, I think, it can be determined that maybe nothing has happened, or if it's been determined that there's actual enough evidence to suggest that misconduct has occurred, there's options such as there's like a full hearing, there's the consent order and agreements that people have. And the reason I'm asking this question too is because when I teach ethics, and so sometimes like I give students generally what I understand, but I'm thinking I don't talk about what the complaint review process involved in its entirety in terms of our meetings. So once you get past that, then it goes to the complaint review committee for decision. And then how is it that, like, then they have the consent order and agreement they can agree to versus going to a full hearing, or they can go to a full hearing of is it the board or is it the complaint review? I'm just curious to make sure I understand that.
Yeah, no, that's a good question. So it really depends on what the finding is. So when cases are brought before the CRC, the members of the complaint review committee, which there are 5 board members who sit on that group, they review and make a determination if they believe that there is a violation of the statutes and regulations. And they have the assistance with legal counsel at that meeting, and I attend, but I don't have a vote in terms of if a violation has occurred, or it looks like we lost Andrew on the call, but I'll go ahead and answer his question, and you can always go back and watch the recording. But yeah, so basically the idea is that once they review those and read through the investigative report, they could just go ahead and find that there is no violation. And then if that's the case, they would dismiss those. They would send a message back to the licensee to let them know that they reviewed it, but there was no determination of a violation. And that's basically the end of it. Some of the other options they have, they could do a letter of warning if, there may not have been a violation, but it may be close to a violation. But if there is a decision of discipline, in certain cases, they do have the authority to do a diversionary agreement on certain matters. If someone has a small issue, let's say with continuing education hours, with the time they renew, in certain cases, they are able to do a small diversionary agreement. Otherwise, they can do a consent agreement in order, which would outline certain disciplinary measures such as supervision or a small fine or different things like that. Or you could have a summary proceeding order. And summary proceeding orders and consent agreement orders are similar, but summary proceeding orders, you have a certain period of time to appeal. And if you don't appeal, those become a final order. And then at that point, those would get posted on the National Practitioner Data Bank and the board website. Consent agreement orders, they would be sent with the terms, and then they could have a dialogue with us, and they could sign that to agree to it, and then we would sign it. And then if those are public, they would be posted on the board's website as well. So, but happy to always revisit that topic, but I'll keep an eye out if Andrew rejoins. The technical issues have been resolved, so we can get back to the training, unless somebody else has any other questions. Okay, well, I'll go ahead and share my screen again here. Okay, so you should be seeing expectations of board members. This was one of the documents that you received. It has formal expectations of board members, and this policy was last modified back in January of 2022. The authority, insofar as the expectations of board members conflict with or limits any federal or state statute or regulation, the statute or regulation controls. So basically it outlines that expectations of board members document is meant to be helpful in terms of board members' responsibilities, but if it conflicts with law, whether in statute or regulation, those are supposed to take precedence. The guiding principles, persons in Kansas shall expect that licensed mental health providers are qualified, competent, and professional, and persons regulated by the BSRB shall expect equitable and fair treatment in relation to licensing activities, disciplinary processes, and administrative regulations. Additionally, the BSRB shall provide all services in a manner that is timely, cost-efficient, courteous, and competent, and the BSRB shall be guided and led by ethical principles, clear policies, progressive thinking, and strategic decision-making. And the BSRB shall respect the dignity and worth of all individuals. There's a little information in the policy there about the services that the agency provides. We process license applications and license renewals in a timely manner. We take disciplinary action when appropriate. We provide timely information to the public, and we maintain rules and regulations and statutes. The expectations of board members document includes a code of conduct, which talks a little bit about integrity. Board members should have no criminal or professional misconduct record, nor commit acts that would lead to investigations or complaints. And board members of the BSRB should possess sound moral principles, such as being upright, honest, and sincere. Board members of the BSRB should have courage of convictions to withstand pressures to be swayed from the public protection agenda. And board members of the BSRB should be honest about personal agendas and leave them outside the boardroom. Further, says that board members of the BSRB should reveal any actual or perceived conflicts of interest and appropriately recuse themselves from decisions or actions in those areas of interest. And board members of the BSRB should not represent their personal opinion as that of the board. And a board member of the BSRB should be limited to one unexcused absence per year. In terms of conflicts of interest, a board member of the BSRB should guard against conflicts of interest. And one of the ways to ensure compliance is the common components of conflicts of interest policies include, but are not limited to, some or all the following. A board member of the BSRB should have no personal financial benefit as a result of service to the BSRB except sustenance and mileage. And a board member of the BSRB who may have a conflict of interest according to stated criteria should refrain from voting on the matter. A board member of the BSRB should disclose any relationship with any other agency or individual involved with the BSRB and be excluded from matters involving such conflict. Further, a board member of the BSRB serving as part of an organization working in any way with the BSRB should inform the board chair. Now, we have received some questions on this item from time to time. It is very common that board members are going to be involved with different associations that may have some interaction with the same topics the BSRB is related to. This kind of goes a little bit further. I think this is mainly relating to any organizations that we may have sort of a business relationship with, or if there is something that involves the vote where a member of the board feels that their vote may not be neutral because of their affiliation with a different organization. Further, a board member of the BSRB should not accept any gifts or promotional items received as part of their affiliation with the agency for personal use. A board member of the BSRB should not use the agency's name or agency information for personal gain. And then in terms of confidentiality, the board discussions involving any of the following matters shall remain confidential unless the board expressly agrees to the contrary. Any discussion that occurs during executive session is confidential, and any discussion concerning actual or potential litigation, that would also be something that would be confidential.
Sorry, I just wanted to interrupt really quick, David. I apologize. I'm stepping away. I just wanted to everybody have a great day. Thank you.
Thank you, you too.
In terms of the board's chair authority, the chair of the board shall preside at all meetings, appoint members to the advisory committee, appoint members of the CRC, and appoint members to other ad hoc committees. The vice chair authority shall discharge the duties of the chair in his or her absence, disability, resignation, or death. In terms of emergency succession, in the event that the executive director is unable to perform the duties of the office of the executive director, the BSRB may request an interim director. If the BSRB is unable to meet immediately, the board chair will seek an interim director until the board can meet. And then there's a little information in the policy as far as the board and executive director relationship. In terms of the organizational structure, the executive director will communicate any personnel matters that should be addressed by the board to the chair of the board. And the chair of the board will present these board-related issues to the board, and the executive director will communicate to the staff the board wishes, intentions, policies, etc. And those are done at staff meetings we have about once a month. In terms of delegations to the executive director shall be the administrative head of the organization, serving at all times under the board. The executive director will be responsible for implementing and executing the policies and activities approved by the board. He shall assist in the developing of the overall program and shall recommend policies and activities for consideration by the board. Another delegation to the executive director shall have sole authority to employ, eliminate, and fix the duties and salaries of other employees or independent contractors of the organization, subject to policies, regulations, and limitations approved by the state of Kansas. Just to let you all know, if we do make hires, the individuals and the amounts that we want to bring them on board do have to be approved by the governor's office. In terms of executive expectations, executive director shall keep the board advised of BSRB activities by issuing a report to the board at each full board meeting, which summarizes pertinent information, and the executive director shall prepare the agenda for board meetings in consultation with the board chair. The executive director shall prepare the agenda in consultation with the board chair for its annual board retreat, which shall allow for issues before the board that need in-depth consideration. And in terms of monitoring the executive director's performance, that document says the board shall, when necessary, utilize executive session to discuss issues concerning the executive director. The board shall also formally evaluate the performance of the executive director each calendar year and on an annual basis thereafter, with emphasis on whether set outcomes are attained. And then moving next to the advisory committees. So to assist the work of the board utilizes 7 standing advisory committees, one for each of the 7 professions regulated by the board. The advisory committee policy is posted on the board's website, and it was included with the packet of material. Currently, there are about 55 individuals who serve on these advisory committees for the board. The purpose of the advisory committees, the BSRB Advisory Committee is a creation of the board, has the purpose of supporting the board in carrying out its mission to protect the public. Members serve at the pleasure of the board, and actions pertaining to informing, licensing, and disciplining are those persons regulated by the board are the method of accomplishing the mission. The advisory committee fulfills its purpose by addressing issues referred to it by the board through the advisory committee chair or the executive director. And a committee may suggest issues it believes the board should consider by referring those through the chair of the advisory committee. In terms of the advisory committee process, so when the advisory committee submits something to the board has 3 options. Either agree the issue needs to be addressed at the board level, 2, agree the issue should be addressed and refer the matter to the appropriate person or committee for additional information, review, or analysis, which will then be brought back to the board, or decide to not address the issue. In terms of the structure of the advisory committees, chairs of advisory committees will be members of the board if the profession is represented. On the board, the chair of the advisory committee will be a board member licensed in the discipline of the committee and appointed by the governor to represent the discipline on the board. Any other board members appointed by the governor to represent that discipline on the board will serve as a member of that advisory committee. In terms of the structure of the advisory committee, a public member of the board will also be a member. There will be a minimum of 3 and a maximum of 10 additional members that are appointed. And the executive director will be a non-voting ex officio member. The assistant director and licensing manager is encouraged to attend, and the assistant attorney general or present legal counsel representing the board should attend meetings when their attendance is requested. In terms of the structure of the committee, terms for the advisory committee members will be 2 years. They will be appointed by the chair of the BSRB, and they can serve up to 4-year term, or four terms, so an 8-year total. Appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. And then there's some language in the policy that says the policies and procedures under which the BSRB board members are expected to operate will also apply to the advisory committee members. And so if you're wondering why we went through the board expectations, part of that is because we do have board members who receive this annual training, but also because of this language here. So a lot of the policies and procedures under which the board members are expected to operate should also apply to advisory committee members. So please be mindful of things like perceived or actual conflicts of interest, making sure that you are following some of the other responsibilities that were put forth in that expectations of board members document as much as possible. And then there is language here that says the chair of the BSRB can remove members from the advisory committee. In terms of the selection of advisory committee members, members for the committee may be nominated by anyone, including the public, committee members, members of the professional organization, either the discipline's own or others, and through self-nomination. In reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographic setting, gender, culture, and ethnicity. Members should provide representation of the levels of licensing for that discipline, and those members should be selected from among public and private practitioners. Additionally, the committee of the whole discusses nominations, so there is no secret voting when you're making recommendations on new members, and they use that process to make recommendations for the new members. The nominee's resume, a letter stating the reasons why he or she desires to be appointed, and a copy of the board's mission and goals to which the nominee has indicated agreement are reviewed. The chair of the committee will submit the committee's recommendations for new members to the BSRB board chair. The chair will review the recommendations and may request input before making a decision, which will be announced at a board meeting. In terms of selection of advisory committee members, after the appointment has been approved by the executive director, the executive director will inform the advisory committee appointee by letter or email. The executive director may assist the new member by providing information which will help orient the member to the board and the advisory committee's goal, role, and function. And then I mentioned that there was a third document, guidelines for attendees of meetings. So the official policy posted on the BSRB website clarifies that public comment is not entitled to individuals, but could be approved. It outlines the processes that should be followed during comments to the board and advisory committee members and topics relevant for public comment to the board and advisory committees. In terms of guidelines for attendees of meetings, it clarifies the board wants to receive valid complaints against practitioners and provides information on how those complaints are to be submitted, but informs potential attendees that certain matters concerning specific licensees will be considered in a closed, standardized process to ensure fairness to members of the public and licensees. In terms of professional licensing boards, we're going to transition now to some general training in terms of members of professional licensing boards, such as the BSRB or advisory committees that assist the work of the board. So the state of Kansas regulates many professions. Each of these professions is regulated by a licensing board or commission that was created by the Kansas legislature for the purpose of ensuring that licensed professionals are competent and do not pose a risk to the public. Professional licensing boards are created by enabling legislation, which creates the board's form, mission, powers, and functions, tools of implementation, and enforcement abilities. The board is considered to be a creature of statute, meaning the board's power is dependent upon its authorizing statutes, and therefore any exercise of authority claimed by the board must come from those statutes, either explicitly or necessarily implied. A board may administer, implement, and enforce only those statutes. If those statutes are silent on a particular action, the board lacks authority to take such action. Simply put, a board can do only what the Kansas statutes say it can do. Besides statutes specific to a board, the authority is limited to the constitutional equal protection and due process rights, prohibiting a board from acting in a manner which results in disparate or inconsistent treatment of persons that are similarly situated. So from adopting different standards for similar situations or acting otherwise arbitrarily, capricious, or vindictively. For example, a licensing board may not impose more severe discipline on male licensees solely because of their gender, or a licensing board may not revoke a license simply because the board does not like that particular licensee. Other constitutional guarantees such as freedom of speech, right to privacy, unreasonable search and seizure, and vagueness also establish parameters for board's authority. In terms of the legislative authority over the BSRB, the Kansas legislature does retain control for certain aspects over a licensing board, such as modifying the enabling legislation, which would change the purpose of the agency and the board. They could limit expenditures in an appropriations bill, which would impact our operations, or they could enact new legislation to change the makeup of the board, scope of our functions, and or the powers of the board. In addition to carrying out its purpose, a board is granted or delegated powers and functions that parallel the three branches of government: executive, judicial, and legislative. In terms of our executive authority, the board carries out its enabling act. We follow the Kansas Open Meeting Act, or KOMA, and we also follow the Kansas Open Records Act. We also have some quasi-judicial authority, and that involves the hearing process and reviewing facts when a violation of law has occurred. Further, we follow the Kansas Administrative Procedures Act at certain times when that is appropriate. Our legislative authority, or in other words, our administrative authority, is to adopt regulations to implement or interpret the enabling act or other statutes with more detailed or specific requirements. This process involves holding an open hearing on proposed regulations, allowing feedback, and there is oversight by a legislative committee. In order to fulfill its responsibility to protect the public from incompetent, unprofessional, and unauthorized practitioners, a regulatory board implements and enforces statutes and regulations, and at times operates according to internal policies. In order to be effective, the board members need to understand the differences between statutes, regulations, and policies. Statutes are laws passed by the Kansas legislature through authority derived from the Kansas Constitution and subsequently defined by the governor. Statutes generally become effective on July 1st of that session or that session year, but can become effective if a different date is specified in the legislation. Statutes set the parameter of the board's authority. Statutes control any inconsistent regulation or policy. If a board becomes dissatisfied with the scope of its authority, such as a board determines that it needs investigative subpoena authority, the board must seek legislation to obtain its goal. In terms of regulations, on the other hand, they're adopted by a board to further implement or carry out the purpose of a particular statute. The board's authority to adopt regulations is derived from the statute itself. In terms of regulations, in adopting rules and regulations, the board follows the Rules and Regulations Filing Act to ensure the process of adopting regulations is open, receptive to public and legislative input, addresses the economic impact of board and those affected, and the regulations themselves are consistent in a style, organization, and grammar, are lawful, and are filed and published. Regulations are promulgated to complete or fill in details of a statutory scheme, implementing statutes, and affect rights or responsibilities of third parties outside of the board. When adopted in accordance with the Rules and Regulations Filing Act, regulations have the force and effect of law. For example, they are legally enforceable. Also, concerning regulations to be valid, a regulation must be within the statutory authority conferred upon the board, implement a specific statute, and otherwise pass the test of legality. Any regulation that goes beyond the authority granted violates an enabling statute or is inconsistent with the statutory power of the board. Another statute or the Constitution will be found void. And then we've mentioned statutes, regulations, policies are also a tool. Policies may be adopted by a board only to guide its internal operations, such as prioritizing staff workload or explaining the investigative process. Guidance documents are documents that state a board's current approach to or interpretation of law, or general statements of policy that describe how and when the board will exercise discretionary functions. In terms of effectiveness as a board member, and also you can take something from this as an advisory committee member, it is recommended to read the board's enabling statutes. That begins with KSA 74-7501. It's found on the BSRB website. It's also recommended to read the board's licensing acts, which are included on the BSRB website. Those are separated out by profession. And also to read the regulations for each licensing act. It's also recommended to read any BSRB policies that are posted on the BSRB website. Additionally, be on the alert for agency policies and internal procedures which may be inconsistent with or conflict with the board statutes or regulations, or which affect requirements for applicants or licensees. Be willing to initiate action to amend statutes or modify regulations. So we mentioned that we have policies that are posted. If you review those and you do have any questions about why something is a certain way, please feel free to let us know and we can have a conversation with you. If a statute or regulation seems confusing or vague, it could appear that way to individuals who must comply with them. And remember, the purpose of imposing discipline against licensees is to encourage compliance with the law and to protect the public. Discipline should not be vindictive or disproportionate to the severity of the violation. Always be mindful that the role of the board is to protect the public, not the licensees. In terms of conflict of interest typically means having any interest, financial or otherwise, direct or indirect, or engaging in any business or transaction or professional activity, or incurring any obligation of any nature, which is in substantial conflict with the proper discharge of the board's members' duties in the public interest. Board members or advisory committee members must make public and recuse themselves from any conflict of interest that exists to ensure the integrity of the board and all of its decisions. Disclosure and recusal are important tools to avoid actual or perceived conflicts of interest, but board members must not overuse recusal as an excuse to avoid conflict in exercising their full responsibilities. Some types of personal conflicts could include those actions that may ultimately have a personal consequence, that is a direct or indirect effect of a decision or action. No decision should be made that will advance the personal benefit of the board member or board members. Examples of personal conflicts include personal gain, bias, or effects on personal relationships. Confidentiality. At all times, a board member or advisory committee member must conform to the rules of confidentiality in dealings outside the boardroom. Protected information obtained in the capacity of board member must maintain confidential during and after the board membership. Termination of board membership does not dissolve the board member from responsibility. And I know at some point, some individuals have asked if they can share information from board meetings or advisory committee meetings. So our meetings are all broadcast. And so if it is part of an open meeting, you are definitely able to share any of that information. None of that is confidential. We will make it very clear if there's any confidential information. Usually that will involve going into an executive session, and that's much more common for the board than it is for the advisory committees. The rules that apply during the active board membership continue and apply after termination of board membership. Confidentiality must be maintained on all confidential subjects that the board was privy to as a board member. Some other examples of times when confidential information could be discussed, as I mentioned, executive sessions during open meetings, or potentially deliberations after a hearing. The Kansas Open Meeting Act and the Kansas Administrative Procedures Act allow the board to deliberate in private in order to reach a decision in a particular pending case. In terms of professional activities, a board member may hold an office in a professional or trade association of the regulated profession, but may not lobby for or cast votes regarding a matter that would impact the professional association or the board member's office in that association. The board member may not use his or her position on the board to further the interest of the professional association or his or her office in that association. Board members may attend professional conferences and social events, but they must be mindful of open meetings, rules, and conflicts of interest. If a majority of board members are present, do not discuss the business or affairs of the board to avoid triggering a meeting under the COMA. Additionally, do not discuss matters related to a particular pending application or a disciplinary matter. Other conduct. A board member should not represent himself or herself as a spokesperson for the board unless authorized by a vote of the board to speak on the board's behalf. If a board member is asked to give the board's position on an issue and the board has not authorized that individual to speak on that, the board member must decline to comment or make clear that any opinions expressed are those of him or herself alone and not the board. A board member should not ask board staff or board counsel to provide legal advice or preferential treatment to any applicant or licensee. Here's a little information about the COMA, the Kansas Open Meeting Act. Under that act, it allows public to observe governmental entities making decisions. Meetings shall be open to the public because the statute says a representative government is dependent upon an informed electorate. Because the purpose of COMA is to benefit the public, it is interpreted liberally and exceptions are applied narrowly to carry out its purpose. The COMA applies to all legislative and administrative bodies and agencies of the state and other subordinate groups thereof, receiving or expending and supported in whole or in part by public funds. The COMA does not define the term subordinate group, but if created by a covered entity or the group has become an extension of a covered entity, most likely the subordinate group is covered by the COMA, which would involve advisory committees for the board. The COMA does not apply to an otherwise covered entity when exercising a quasi-judicial function or covering a proceeding or hearing under the Kansas Administrative Procedures Act. COMA also does not apply to the judiciary, private organizations, or staff meetings of a covered entity. A meeting is defined as any gathering or assembly in person through the use of a telephone or any other medium for interactive communication by a majority of the members of an agency or public body subject to the act for the purpose of discussing the business or affairs of the public body or agency. And I just want to stress this. I know sometimes individuals may think if we don't have an official meeting, this doesn't fall under COMA. but really you need to be looking at what constitutes a meeting by this definition. So it can be any gathering, whether it's in person or by email or by phone, as long as you have a method of interactive communication. You have a majority of membership of that body, and it's for the purpose of discussing the business or affairs of the public body or agency. Meetings may be conducted by telephone or other electronic medium, such as Zoom, Skype, etc., if the board complies with all COMA requirements. A meeting includes informal discussions before, after the public meeting, or during a recess of a public meeting, and all gatherings at all stages of the decision-making process. The name of the gathering is irrelevant, thus work sessions and retreats are subject to COMA. So as I mentioned, the board's offsite planning meeting, even though it's going to be offsite, is still open to the public and is considered a public meeting. A discussion does not necessarily require binding action or voting. A discussion can occur at social gatherings, retreats, and other meetings held in private, educational conferences, seminars, etc. Thus, when traveling to such meetings, members of the board should avoid discussing business or affairs of the agency if those discussions would involve a majority of the members of that group. The presiding officer has the duty to provide notice of the meeting, but this duty may be delegated. So on behalf of the BSRB, we put out all the public notice about meetings and make sure that's not only on the agency website, but it's also on something called the Public Square for the state of Kansas. So if you've ever been to that website, you can see all the meetings for different organizations under the state. The COMA does not require notice of the meeting to be published in a paper or on a website. An individual must request notice of meetings. There can be no formalities, or there are no formalities to requesting notice that can be verbal or written. The notice must provide the date, time, and location where the body will meet to the person requesting notice in a reasonable time before the meeting. A request is valid for 1 fiscal year, and the board must notify a requester of expiration before terminating notice to that requester. When we put out public notice, we also do send an email with the dates of any advisory committees or board meetings that have been scheduled. The COMA does not address meeting procedures. A board is not required to follow Robert's Rules of Order or any similar rules of procedure. The COMA does not require a board to create an agenda, but if one exists, it must be made available to everyone. A person may record the meeting if doing so is not disruptive. The public does not have the right to speak, but only to listen and observe, and the board cannot vote by secret ballot. A board policy may require minutes to be kept, but the COMA does not require the board to have minutes unless there is a motion to go into executive session. The motion as made must be included in the minutes. An executive session permits discussion of certain enumerated matters outside the public view. To make an executive session or take an executive session, the board must first convene an open meeting. The board cannot take binding action in an executive session, but a consensus is allowed. If a consensus is achieved, the board must reconvene the open meeting and take a formal vote during the open session. Prosecutions under COMA are civil, not criminal. Any person, county, or district attorney of the attorney general may bring an action in district court. The county/district attorney and attorney general have subpoena power, and enforcement actions take precedence over all other cases that are assigned for trial at the earliest practicable date. The remedies for a COMA violation include voiding any action taken if prosecuted by the attorney general or county or district attorney, an injunction, stopping the action, a mandamus, forcing action, or a declaratory judgment. The penalties for a COMA violation include a fine up to $500 per board member, not the board, for each violation, ouster from office, recall from office, court costs assessed to the person seeking enforcement of COMA, court costs assessed against the plaintiff if maintained action previously not in good faith or without reasonable basis in law or fact. And now let's move to the KORA, the Kansas Open Records Act. It requires the board to have its records open for inspection by any person unless otherwise provided, and KORA, quote, shall be liberally construed and applied to promote such policy. A public agency includes the state or any political or taxing subdivision of the state, or any office, officer, agency, or instrumentality thereof, of any other entity receiving, expending, supporting in whole or in part by public funds appropriated by the state or political taxing subdivision. The term instrumentality is not defined by KORA. Nevertheless, if created by a covered entity or a group has become an extension of a covered entity, it will most likely be covered. A public agency does not include private companies, even if they receive public funds in exchange for goods and services, judges and courts, an individual legislator or member of a governing body, private individuals, or state employees. A public record includes any recorded information regardless of form or characteristics which is made, maintained, or kept by or is in the possession of any public agency, and written records, photographs, computer data, and email. A public record does not include records that are owned by a private person or entity and are not related to functions, activities, programs, or operations funded by public funds, or records not in existence at the time of the request. The board is not required to seek a record in order to fulfill a request. Under the CORA, the board must appoint a Freedom of Information officer to assist with CORA records or CORA requests, which Leslie Allen is that person in our office. Display, distribute, or otherwise make available a brochure describing requester rights, agency responsibilities, and procedures for inspecting or obtaining copies of public records. And we have such a policy. It's on the BSRB website under policies. And under the CORA, we must include the name, title of a records custodian, fees, and office hours available for anyone to make such a request, which is also included in that document. In Kansas, any person may make a request. The person need not be a resident or provide a reason for their request. The board may require the request to be in writing, state name and address of the requester, provide proof of identification, and sign a petition, a written certification that the requester will not use names and addresses obtained from the records to solicit sales or services. Unless closed by law, the board cannot deny a person the right to review its public records. For instance, copyrighted material may not be reproduced or without the permission from the copyright holder, but must be made available for viewing or listening. If portions of a record are closed, the remainder of the record must be made available to the requester, and this referred to as a redaction. The board is not required to make copies of recording tapes or discs, videotapes or films, pictures, slides or graphics, instruments, illustrations unless shown at a public meeting. The request must be acted upon as soon as possible, but not later than the end of the third business day following the date the request was received by the board. 3 responses are acceptable. 1, the record is provided in the form requested if possible. 2, the request is under review and the records if permitted will follow. Or 3, the request is denied and a detailed explanation for the denial. So under this CORA request, if we do receive a CORA request, we are obligated to make a response within 3 days, which we do. But if their records are not clearly able to be turned over, then often we send a letter that says we will be reviewing our records to identify if we have anything relevant to this request. In terms of your responsibilities, we'll get into that just a little bit. Under the CORA, there's a presumption of openness. As such, the requested public records must be released unless an exemption to disclosure applies. The burden rests on the board to prove the requested records are exempt from disclosure. Exemptions to disclosure may be discretionary or mandatory. The CORA is a civil act, not a criminal act. Any person, county, district attorney, or other attorney general may bring a civil prosecution, and then you see similar language to what you did under the code. In actions brought by the county district attorney, the fines up to $500 per violation may be imposed for a knowing violation or an intentional failure to furnish information. Cost and reasonable attorney's fees, etc., may be imposed if the board's denial is not made in good faith and without a reasonable basis in fact or law. So one thing I will say before moving to the CAPA is that we handle CORA requests here. However, please be mindful that our communications with you are still records and could potentially fall under CORA requests. That's why we recommend that if you do have any communications that involve business, in terms of you being an advisory committee member, it's always helpful to copy myself and sometimes Leslie Allen on those types of communications, because that way it's on the server for the agency. And so if we're asked for any records, we can go ahead and send those out. But just be mindful, I know some people think of records as an official letter or document, but records could even be things like text messages or any kind of communication that is a document. So please be mindful of that. I know you're all professionals, but it's always helpful to get a reminder about that and what constitutes a record. Under CAPA, most of this is going to apply more to board members and advisory committee members, but I'll just go into a little bit about the CAPA. This has to do with creating procedural rights and imposing procedural duties. Under the items for the board's Enabling Act and Licensing Act, CAPA is used at certain times, such as when the board is reviewing materials for an individual applicant, and also in order for us to do deliberations for hearing when individuals have requested a hearing or denial of a license application or conditions. The general rule is that licensing boards like the BSRB must do business in an open meeting under the COMA unless directed by statute to conduct the proceedings or hearing pursuant to the CAPA, which is what we have as our direction in law. And so when we when we do have language that provides that something will be under CAPA, we will follow CAPA, not the COMA. And then CAPA sets up the procedures to follow when the board is deciding what to do in a case. These have to do when we're deciding cases involving individual licensees, where some of that information is confidential and private. However, if we're having a discussion with the board in terms of an across the board type policy, that is something that would not be considered confidential, and we would have those discussions in an open board meeting in front of the full board under the COMA. I'm going to move ahead here on some of these slides, but basically it just kind of talks about what would fall under CAPA, usually those confidential matters, and then other matters that would involve an open meeting would fall under the COMA. Under the CAPA, neither the public nor the applicant has to be notified when the board meets to consider an application for licensure. However, if there is a decision that there is a condition or denial of licensure, there is an opportunity for an official hearing, and that is sent to the individual to request. Under the CAPA, the board and the CRC do not need to take a vote in public for decisions to be made under the CAPA. But if they are made, like I mentioned, they are sent for the individual to request a hearing if they choose to do so. There are some board activities that are not covered by the CAPA, and these must be under an open meeting. These are approving board minutes, discussions and votes to approve or amend regulations or guidance documents, delegating authority to a board member or to the executive director for a particular action, receiving agency updates regarding the budget, legislation, statistics on complaints, and CRC activity, education, and the executive director's report, decision whether to renew a contract or change the way contracted services are provided, and policy decisions affecting the way the board operates internally. There's more information here that basically says the CAPA will oversee the individual who applies for licensure and what standards they have to show, and what standards have to be met for the license to be conditioned, such as restricted with supervision or other penalties. If the board denies conditions or restricts a license, the applicant may request a hearing if the applicant did not agree to such action in the consent agreement in order. And then it talks a little bit more about how CAPA applies to the investigations of the board. And when we're discussing potential violations by specific applicants, those are in a closed session under the CAPA. And unless the individual receives a determination that there has been a violation and a proposed summary proceeding order or consent agreement order or a diversionary agreement. And this talks a little bit about how the CRC goes through its process to find reasonable grounds that an individual has violated those provisions. More of this is on the section regarding to the CRC. So I know Andrew had mentioned a question about the process the CRC uses to make these violations. Just in the interest of time, I'm going to move forward on these, but there is some information here in terms of the process the board follows and members of the CRC follow in general on those reviews of complaints. There's also some provision under the CAPA for an emergency action in certain situations. And there is an opportunity, even in those cases, for someone to request a hearing. And there could be also an emergency order that goes to district court on appeal. But then the last item I'll talk about here is the Kansas Tort Claims Act. So the general idea is that it governs liability of state of Kansas and its agencies and employees. And the general concept is that if employees are performing their duties, or if you are a member of a board or committee of a governmental entity serving under your specified functions, whether you're compensated or not, is that vicarious liability for any actionable wrongful act or omission of a government employees within the course or scope of their employment, subject to affirmative grants of immunity that may exist on a case-by-case basis. And so if you are sued for an act that occurred within the scope of your duties as a board member or an advisory committee member, you are entitled to have the state defend you at no cost. So if you are ever notified that someone is suing you because of your functions or your role as an advisory committee member, please let us know as soon as possible. There are ways in which the Attorney General's office will represent Kansas board members or advisory committee members should that ever come up. It would fall under the Kansas Tort Claims Act, but there are certain processes we have to follow for that to happen. And so just let us know if that ever occurs. And then we will let you know. But we do have an Attorney General's opinion concerning if that applies to advisory committee members or just board members. And that opinion by the Attorney General's office was that it would apply to advisory committee members as well. Now, to my knowledge, I'm not aware of an instance where this has occurred, but I always find that it's helpful just to kind of let you know about that should it ever come up, because it is kind of an important topic. So I realize it's a lot of information. We covered a lot of ground here. I do encourage you to go back and watch any of this if you want to refresh your memory on any topics that we covered real quickly. But I think it's important that all the members get this training once a year. So right now, I'll go ahead and stop and see if there's any questions on the training.
Thank you, David. Any questions? I know that's a lot, but it's all very important. I don't hear anything for now. Jim, were you getting ready to say something? Okay. So if you have any questions, David is available. I'm available. Be sure and reach out if anything comes to mind, or if you go back through and cover that information later, just let us know.
And Laura, I'll just say two things real quick, because I think sometimes after training, there can be two areas where people do have questions. So I'll go ahead and head those off. One, the main thing about the open meeting is that email communication can be considered a meeting for the purpose of communicating back and forth. And that's why we don't want advisory committee members to be having those back and forth email conversations, because it's not an open meeting. So any discussions where it involves the majority of members for the purpose of the committee, that needs to happen in an open meeting that we're broadcasting, basically like this. However, what that doesn't mean is that you can't communicate with one specific person on the advisory committee. So if you want to reach out to Laura, if you want to reach out to me anytime, feel free. If you want to contact any of the other members, just make sure it's not something that would involve the majority of members of the committee. But if you do have a question about something, or you want to work with someone on a topic, you're more than welcome to do that. It's just it becomes a problem when it involves the majority of members of the committee.
Great. Thank you, David. Okay, so the good news is we got through that very important and comprehensive piece of training. The bad news is we're out of time to do old business and new business. So I guess what that means is that our next meeting in October, we will start fresh and dive right into old business and new business. Do I understand that correctly, David?
Yeah, and I would recommend members go ahead and just review the materials. Some of them were going to be touch-up items from the last meeting, just to kind of close the book on that. So for the other items, just feel free to review those and come into the next meeting ready to discuss those topics.
Anybody have any questions about that?
David, will you have the PowerPoint up on the website, or is it just on the video?
I will go ahead and I'll have our staff upload it to the website. It will be under the materials for this meeting. If you go to the BSRB website, we always post the materials under About Us. There's a separate page per advisory committee. And so currently right now that has the agenda and materials for this meeting. And I'll just have one of our clerical staff members post that PowerPoint as a PDF right where the section does it for the training materials for this meeting.
Great, thanks.
Thanks, Bob. Anybody else?
Move to adjourn.
You're on top of it. So I need, okay, so Jim, I have a motion to adjourn. I need a second.
Second, Bob.
Thank you, Bob. All in favor, say aye.
Aye.
Any opposed? say-
Cindy, how are you?
Thank you.
Good,
All right.
that's good. Is
Any
Judy
opposed, say nay.
available? Yeah, I want to talk over mom's schedule.
I don't think that's meant for us, so
Okay.
I don't see any
Okay.
opposed, so we'll go ahead and adjourn.
All right. Thank you, Laura.
Thank you so much.
Thanks.
Take care.